Please be seated. This is the time scheduled for oral argument in Midtown Medical Group, Inc. v. Farmers Insurance, our case number CACV130276. Each side's been allocated 20 minutes for oral argument. If the appellant desires to reserve time for rebuttal, you can do so. As you know, there's a clock on the podium, and that shows the time, including your rebuttal time that's remaining. To assist both of you, you should be aware that we have read the briefs, we've looked at the record, we've looked at the cases, we've conferenced this case, so we're relatively familiar with the facts and the law on this, and the issues on this. Even though each side's been allocated 20 minutes for oral argument, that doesn't mean you have to use all 20 minutes. If you're done speaking and we don't have any more questions, feel free to sit down. Finally, you should be aware that these proceedings are being audio and videotaped or recorded. So when you approach the podium, please clearly state your name and who you're representing. With that, counsel for the appellant.
Thank you, Judge Kessler. My name is Eleanor Miller, and I represent the appellant in this case, Priority Medical Center. Mr. Coast is here too. He's the administrator of the center. I'm not going to spend a whole lot of time on that first argument. If you just look at the title of the statute, you will see why I was somewhat upset at the court's ruling in this case. The title is Release of Claim by Injured Party Ineffective as to Lien Holder. Action to enforce lien. And then in subsection B of the statute, it talks about where you bring the action and where it should be filed and where it should be tried. So the argument that was made to the trial court that we can take care of this by writing a joint check that PMC never sees, never gets the opportunity to cash or get its lien out of. Somehow that convinced the trial court that the 1968 case that she cites in her minute entry was controlling.
Let me ask you a practical question here. Let's say and let's assume that we agree that the court made a mistake of law and that 33934 did not applies as you have argued. What does an insurance company do when it is paying out a settlement sum to a individual who is not represented by counsel? Now, the joint payee check is perhaps a good idea. At least there's something. That's helpful. But what else should they be doing in this situation? I mean, from a practical standpoint, why should they? I know they should follow the statute and get a release, but how do they go about doing that?
They contact my client.
Do they send your client the check?
Most insurance companies do, yes. This particular insurance company.
And hope that your, and I don't mean any disrespect, but a person in the position of your client will then cash. What do? Get the endorsement from the other payee?
They call the patient in. They say, here's the amount of money. My client may negotiate with the patient if the amount that the patient settled for is not sufficient to cover the lien. That part is between my client and the patient. But what the insurance company is supposed to do is exactly what they said in dicta in McReynolds, which, by the way, Judge Portley, you concurred in. I've cited that case in there. I've cited the paragraphs which contain the essentially what I have been arguing from day one in this case. And that was the interpleader case. I don't, if the court remembers. The insurance company, there was the cap on the insurance was not enough to cover both the provider and the injured. The injured refused to settle for the cap, and so the insurer did what the court said it should do, and that is to interplead the amount of money and ask the court to help it out in sorting this problem out. And in so doing, the court said, yeah, that was the right thing to do, because look at the statute. If they don't do that, if they don't get a release from the lien provider, they are still going to be liable to the lien provider, and the lien provider, or the health provider, and the health provider can go after both the insurance company and its insured. After I read McReynolds, I thought, why am I arguing here? I mean, if you can read the statute, and I know that this court can, you can see that what it establishes is a requirement. So at a minimum, the insurance company is going to let the health provider know, hey, we've settled this case. We're going to send out a joint check. In our case, we have benefits assigned, stamped all over our documents anyway, so and asked that the check be sent to the provider, but they didn't do it. And then you take care of it from there. They make out a joint check. They send it. If they want to send it to the patient.
May I ask you to scroll back for a moment? The letter that your client sent to farmers, forgive me, and I can go look it up, and I will, but did that letter state that when farmers makes a payout, it needs to send the check to your client? I thought it just said include PMC on the draft.
Yeah, that's Exhibit A, I believe, to our complaint, Your Honor. And, what's quoted from it is not the entire letter. Oh, this is my appellate, I'm sorry.
I have it.
Exhibit A to our complaint. I have so many stickies here, I don't know what I'm... The first paragraph says, please find enclosed a copy of our lien contract and authorization to release medical records from Priority Medical Center and assignment of benefits, medical records, and the bill for services provided. Then it goes into the furthermore, blah, blah, blah. Due to past difficulties getting insurance companies to honor our lien with first-party claims, we have also entered into several agreements with the patient embodied in this contract. The copy of this contract is being sent to place your company on notice of the terms of the contract. That goes to the intentional interference of contract cause of action. And then the very last sentence, if payment should be made to Miss Shelby Davidson without the inclusion of our name, we will hold your company or any other parties making said payment responsible. As you know, the courts have consistently held that insurance companies are obligated to protect a valid lien. Then if you look at Exhibit B, oh, that was Exhibit B, I'm sorry. Exhibit A is the letter that went out, and this is what they were referring to, that in the lien. And in the very last paragraph, the patient says, I am directing any and all insurance carriers, including but not limited to applicable uninsured and underinsured motorist coverage, to protect the lien rights of PMC and honor the contractual obligations between PMC and myself. That letter nothing was intended to say, okay, if you put our name on there, we're going to give up our lien. I mean, these things were sent to protect the lien. That was the purpose of those documents, was to protect PMC's liens. And to read them as my opposing counsel has read them, I think is is simply a fallacy. And you know what? I think that even if that's what it meant, they still had an obligation under the statute to honor the lien. Just throwing that out, because what that statute says is what it says.
On the tortious interference count, let me assume for the moment you have pled a valid contractual relationship based on these letters and the materials that were sent to farmers. Farmers knew that there was a contractual relationship. But what evidence did you present that farmers intentionally induced the patients here, the two patients, to breaching their agreement?
Well, Your Honor,
with your client?
With respect, it's a little hard to prove facts if you don't get into discovery.
Well,
And the 12B6 motion
but-
cut off our discovery.
Go ahead.
I was going to say, but it's the well-pled, just because you say it, it's more conclusory than, because that's what the trial court ostensibly was looking at, and we have to look at. Just because you said that, that's what they intended for
Well,
the person receiving the check to stiff PMC, doesn't
Let's-
make it so.
let's look at their conduct, Judge. My client called several times, he had conversations with one of their adjusters who said, you know, take a slow boat to China. We don't care if you didn't get paid. When I got in contact with Mr. Demlong, same thing. You know, we paid a joint check. We don't have any obligation. They just ignored 934A. Just ignored it.
But all of that, and I can sense your frustration, but the issue for the tortious interference is that farmers induced these two individuals to breach their agreement, their contract with your client. And that's where I'm not seeing how you met your burden in withstanding.
I think perhaps the most important fact is they don't do this with patients who are represented by attorneys. They do it with patients who have very small amounts coming to them and are not represented by counsel. And as a result of that, they can send the check directly to them and just say to PMC, hey, we sent them the check, we're all done. Knowing full well that there's a strong possibility that for $349 or whatever it was that they sent to Ms. Davidson, for example, that she's not going to pay
So
the amount of
implicitly,
money.
the farmers is appealing to their baser interests and not to their higher angels? Is that the idea?
I am reluctant to say that we do have information that leads us to believe that Ms. Baruman did have conversations with Ms. Willis, but at this point it's not in the record because I couldn't.
We're not there yet.
We're not, okay.
I wasn't there yet. We also have information from Ms. Davidson, but that's, again, not in the record. The Plattner case sets forth what we have to allege for a prima facie case. We did that. That's what we alleged. Then Wagon Seller talks about 766 of the Restatement of Torts, and it talks about all these different things, all these different factors that have to be taken into account to determine whether or not this was intentional, wrongful, etc. And you can't possibly get into that. I can't possibly allege, other than the nature of their conduct, what I believe their motive to be, I knew what the interest interfered with, and so on, but it's
Couldn't you have
very
called them
difficult.
up?
Pardon?
They're not represented by counsel. Why can't you or your client call them up and say, ladies, you have these monies, what did you do with them? And get information and then plead appropriate facts.
That would have been an opportunity for my client, yes, to plead those facts. But very frankly, I just thought that the conduct of the insurance company alone, which can be inferred from the way they handled this, is sufficient to survive a 12B6 motion. And as we know, that standard is very low.
Counsel, except for the tort claim, everything else is really just trying to enforce your lien, correct?
That is correct, Your Honor. With the exception of the contract issue, whether a check is or is not a contract.
But still just trying to enforce your claim.
Yes, but
enforce the lien somehow in different theories of trying to enforce your lien. The only claim that you have for other damages, is that right? Is the tort
Yes.
claim, tort interference with contract?
yes. Well, actually, this is a claim for damages. Our position is, since there was a contract made when they signed it, and that we can sue on the underlying obligation of that contract. And one of the things that this case gives this court an opportunity to do, and I'm going to stop talking very soon, is to make a statement about whether or not the UCC says a negotiable instrument is a contract, or a contract is a negotiable instrument.
But from your client's standpoint, it doesn't really care how we get to the result. It just wants to say somehow that it can still proceed against, that it has a claim against the insurance company for the lien, the amount of the lien.
Absolutely, Your Honor. I'm going to stop there and reserve some time for reply.
Thank you, counsel.
Good morning. William Demlong and Paige Pataki on behalf of Appellee Farmers Insurance Company. The trial court got it right when it was talking about Section 33-934A. The statute protects the medical care provider from insurers who act in derogation of liens, but it doesn't make the guarantors, or excuse me, the insurers the guarantors of the lien. If you look at...
Well, but they're not, the statute is not making a guarantor. They're just making sure that you ensure through negotiation or otherwise that the lien is resolved.
Your Honor, what the statute, what we contend it says, the first sentence, there's two sentences in A. The first sentence says, look, the insurance company or the tortfeasor and the claimant, they can't create a release that will also release the lien holder. That's all it says. So if the release is also signed by the lien holder, then the whole thing's extinguished and we're done. That is all the first sentence says. The second sentence is the one we're really here about, and that is, okay, if the lien holder's not a party to that release, then they still have the right to enforce the lien. And that's all the second sentence says. So then you have to go to, so what does that mean?
Oh, but it says who they can enforce it against.
Correct. And one of them is the insurance company. We understand that and we agree completely with that. So then you go to, well, how do they go about doing that? All right? And
well, the answer isn't the answer then in the first sentence, which is, if you want to protect yourself, insurance company, you get a release or have the healthcare provider sign off. It's really that simple. That's how you do it. I don't see how issuing a joint payee check at all begins to comply with the literal language of this statute, that if you want to protect yourself, insurance company, go get a release from the health provider.
Your Honor, I respectfully disagree with the way the first sentence reads. The first sentence says, a release of claims on which a lien or assignment is given by 33-931 of any judgment claim on that claim is not valid or effectual against the lien or assignment unless the lien holder or assignee joins in the release or executes a release in the lien or assignment.
Right.
So what it's saying is, if they're not a party, they still have their enforcement rights. It doesn't mandate that they be a party.
It's true. They don't have. You don't have to. There's nothing in here that says you have to issue a joint payee check. There's nothing.
Correct.
But if you don't get them to sign off on a release, That lien is not extinguished.
The lien's not extinguished, but we would submit to you that the joint check is a method of ensuring that the lien rights, to the extent there is any benefit underneath, any monies owed, is covered through that joint check.
How is the issuance of a joint payee check that is never, ever endorsed by the provider, how does that then become the provider's release when they never, ever endorse it?
Well, I don't think it becomes the release because I don't think they need the release. The second sentence says, Blankenberry, which we cited, and you saw that, basically says that you can't operate in derogation of the lien.
How's that not in derogation of the lien?
Well, because the joint check, Your Honor, is all the money that is owed to, in this particular case, the injured party. The medical provider's lien with respect to the insurance company only goes up to whatever that settlement amount is. They're on the check, and at that point in time, just like the other cases we cited to, Brown Wholesale and Wells Stewart's, it's just like a general contractor with a material man and a subcontractor, the way they can protect their rights.
No, it's not. The joint payee check rule in the construction contract is designed in large part to prevent a double payment by the general, but also to protect the material man. And so if the material man gets the check and they sign it, that is presumed to be an acknowledgement of payment in full. And that's just not at all the situation that happens here, because the person who would be analogous to the material supplier would be the provider, the healthcare provider, not the patient. Healthcare provider here didn't sign anything.
Well, if the check was signed, and again, we'll get to that issue too, but Your Honor, if the concept is still the same, the joint payee is to make, here's what I would call it akin to, and we talked a little bit about McReynolds. That's a perfect example of how things have operated in Arizona forever, which is, in that particular case, you had the liability carrier had a policy limits, and Judge, you probably know it, I'll just say $50,000. Medical expenses were greater than that. So what does the carrier do? It writes a joint check to both the medical care provider and the individual. The individual says, no, take the medical care provider off. And so I do the offer a judgment, and you have to pay that. Well, what did the insurer at that point have to do is interplead the funds because they had no choice. What I would submit to you, a joint check is similar. It's a non-judicial interpleader in a way. It's the parties. This is the sum that the other entity owns. They give a joint check to the parties, both of whom have to sign. If they can't come to a resolution on the payment or whatever, and it never gets endorsed, then of course then the insurance company is going to be back into it.
But the interpleader is filed with the court, which is a neutral party. By that theory, you would say, well, if I gave a check to one of the parties that's in a dispute with the other party, that's an interpleader. That's not an interpleader because it's not given to a neutral party.
No, Your Honor, but what it is doing is it's giving the monies to the individuals, the two parties that claim a right to it, to decide what their share is, much like the material man and the subcontractor.
But that doesn't relieve you of that obligation if, in fact, it goes south, as it has. Ms. Miller brings you in, then you have to decide whether to sue the tortfeasor or bring the bank in or do whatever you need to do to protect your interests, but the statute doesn't release you.
Well, we would submit to you, though, Your Honor, that that's where the interplay between this statute and then also the UCC with respect to joint payments of checks. Clearly what happened is Davidson, endorsed the check and she wasn't supposed to. Under the UCC that we cited to, the bank depository bank has an absolute duty then to pay that because they're the ones that were the gatekeepers to ensure that was done right. We would submit to you that's how the system works, and it's been this way, quite frankly, for decades in these kind of contexts. The joint check is out there. If the parties can't agree, you're right, Judge, then the insurance company is going to have to deal with it one way, either file an interpleader action or something like that. typical result would be, and even counsel talked about, if they get the check, they negotiate. So there's always going to be negotiations on these things. What can't happen is one party surreptitiously endorsing for the other. At that point, the bank is the gatekeeper, and the bank is the one that would have the obligation in addition to the patient.
But you prevent all of that. I mean, the insurance company, it's not so, I mean, getting away from the language of the statute just for a second, the practicality of it is the insurance company can short circuit all of that. Instead of sending the check to the patient, as a joint payee, and hoping that the patient doesn't forge the provider's care, they just send they send the check to the provider with a copy of a cover letter to the insured, and let them let that take the route, because invariably I would imagine the healthcare provider is not going to be cashing that check without the patient's okay.
Well, you're assuming something. I'm talking about the law. What if they do? No. I don't mean that. No, obviously,
I take no offense. He does it all the time, so it's okay.
But let me answer that. What precludes a healthcare provider from negotiating without the individual signing it? What precludes that whole reversal of happening?
Presumably, the first thing you're going to do is you're going to get a release from the lien holder.
Well, see, but you're getting back to the release.
You're going to send them the check and say, with this check, you have to sign a release, or your endorsement on the check it constitutes a release.
Well, but Your Honor, you still have. But then what happens to the claimant if the lien holder signs a release and they cash the check and use all the money? The lien holder, now you've got the party who you've already signed a release with, right? The tortfeasor and the claimant. Now the claimant is saying we're not getting paid.
Or you send a letter to both sides and say, we've got this check. When we get a release from the insurance company, decide, send us something, send us a signed form that says how you want us to divide it up. Simple as that.
Well, Your Honor, that may very well be the case. That's not what the statute requires.
But the statute the statute very clearly says this lien is not, unless there is a release on that claim, it's not valid or effectual against the lien unless the lien holder joins in the release or executes a release. It says nothing, nada, about joint payee checks. You got to have a release, otherwise that lien just keeps trucking along.
Your Honor, I agree with you on that. Okay, but the way we only owe so much money.
I
correct?
agree. You should only owe so much.
All right, so we owe what we owe. And again, if that was all that was required, then you wouldn't really have a need for the second sentence. The second sentence talks about that it continues. And again, Blankenberry talks about the fact that if you're in derogation of the lien, then you can go after the lien holder in this circumstance.
That's Blankenberry, but the language of this statute is real clear. If an amount has been or is to be collected by the injured person, that person's legal, or goes on, liable for damages by release of a judgment compromise, the claimant or assignee of the lien, which would be the lien holder, may enforce the lien against, and our legislature added the magic words, and against any insurer.
Correct.
Right.
And maybe we're just going in circles in the whole sense of the joint check. I believe the purpose of the joint check provides that mechanism to ensure that they are protected through the enforcement of the lien.
Clearly, with honorable people, a joint check should have been one appropriate way to comply with the requirements. Then the provider would have signed off and they would have worked it all out. What strikes me about this situation is that what we're dealing with really is risk allocation or assessment and the cost of doing business. It strikes me that because these amounts are so small, one could argue that your client wants to put the burden and the expense on the provider versus having your client, who is in charge and has the pot of money, taking the burden and the expense of making sure that there are appropriate lien releases before the monies are actually dispersed. and that this statute was designed to really put the onus on the payor to go to the advantage of the healthcare provider. And that's what we're really dealing with is risk and expense, the cost of doing business.
Well, Your Honor, I don't disagree with that's what's happening here, but I think that you have to add in the additional state statute talking about the endorsee issue of when there's a converted check. And that brings in the bank who is now signed, or the depository bank who has cashed a check that was inappropriately endorsed, and so there's an avenue there.
But, at least according to the briefing, and I don't know if this is part of the record, but I'm going to assume for the moment it is, your clients would provide the provider here with no information or any help on trying to get these monies from the depository bank.
Well, I think that the record says that we didn't go after and find the depository bank. That would be correct.
Well, kind of want it both ways, don't you?
Well, Your Honor, I would respectfully disagree. I think that the joint check in the grand scheme of things, and as you said, Judge Kessler, most times this is going to work just fine. This is how it's been done. It's continued to be done. I can guarantee you today there's probably been hundreds of these kind of things going on. That's just how it's done. To change the way the Arizona has been operating this when it's been working just fine with the protections. Again, there's protections in here for the medical care provider, one being the going after the bank, the depositing bank, two being going after the actual provider who, the actual recipient of the care. And when you're talking about, can I finish one more?
Recipient of the care is.
Pardon me?
Recipient of the care, yes, I guess they could go after the recipient of the care, but in most cases, that's not going to be a very fruitful exercise. And the bank, perhaps that's a remedy if the payee, the healthcare provider, had standing to go against the depository bank.
Well, the healthcare provider is a payee on that joint check, so they absolutely do.
Normally, it's the drawer. I thought it was normally the person who writes out the check that can sue the depository bank for honoring the check. Because normally what happens is the person takes the bank, the payee who falsely endorses it, presents it to their bank. It gets cashed. It goes up the chain, goes to the bank that the check was drawn on, your client's bank, and then they should say, wait a second, this isn't a proper endorsement. If they honor the check, and then it later comes out they improperly dishonored it, you could then go against them, and they can go back against the bank that initially cashed the check. I'm not sure the positive the payee has standing to do that.
Your Honor, and this isn't in the briefs, but anticipating more discussion on the check issue, there is a couple cases I'd like you to at least consider. One is talking about joint payee checks. It's Cook versus Great Western Bank and Trust, 685 P. 2nd, 145, pinpoint site 151. And again, that's not in the briefs. I thought if we got down this, I'd at least bring this along. With that, one of the things that case represents or stands for is the delivery. And talking about joint checks, the delivery may be actual constructive, and delivery to one joint payee may be deemed constructive delivery to all payees. So that's talking about, again, now we're shifting to the UCC and our joint check discussion. So we believe that would be a constructive, acceptance of the joint check for everybody. And again, another case that's not in the brief, but I'll give that to you as well as Berthot.
Berthot.
Okay,
Yes.
okay.
I know that
okay.
case.
Oh, okay.
That case, yeah. Yeah.
Anyways, that one just said, I'm quoting it, God knows what else is in there. I'm just quoting it for the proposition
The
that.
lawyer in that case.
Oh, were you? Okay.
Oh,
Yeah.
dear.
Well,
Oh,
the code, if you remember, Judge Portley, in there that said that the code imposes an absolute liability against a bank that pays money on a check based on a forged endorsement. So our point is that.
But what if the endorsement wasn't forged? They just signed their name to it with a deposit slip, stuck it in the ATM machine, it goes through the process, your bank gets it and says, okay, because, banking has changed since Berthoud.
Well, but what you're saying, there's only one signer to a joint check.
Correct.
I would say it's still constructively not properly endorsed.
Oh,
And it would still be
sure.
the, but so the
But
same.
it's your bank that, when it pays out on that, is probably, the problem, not the accepting
And
bank.
in essence, that's your remedy. If you have to pay that lien, so you have to pay twice, you can go to your bank and say, wait a second, where's that check? You shouldn't have paid out on that. And then they can go back down the line, right back to the other payee. Isn't that and just think how all complicated that is.
Oh, dear.
With negotiable instruments and wire transfers, as you remember. And instead of saying, parties, we follow the literal language of the statute. We need a release. Parties, we have a check for $500. Please sign the appropriate forms and we'll issue checks to both of you in the amounts you've indicated in the form. You'd avoid all of this.
Well, Your Honor, that may very well be in this case. One thing I could also say is the medical care provider, likewise, they have their own form. We actually did exactly what they said, which is to do the joint check. If you want to go that route, they could say and send it to us and have the other person
But you could
write that
easily
as well.
just say, send out the two forms. Here's the amount. The two of you would discuss, how much there's going to be and let us know. Both of you have to sign this form, send it back to us, and we'll issue two checks. One to the insured, one to the lien holder, and we have the releases. And you're done. It's so simple. I'm just looking for a simple way, we don't want to make render a decision that creates problems. It seems to me this makes it simple.
Well, Your Honor, I would submit to you the way it's been working up till now in the state of Arizona has been working quite well, which is the joint check, which gives the, I know I'm out of town, but gives the medical care provider or whoever else is the second party in the joint check on it that's been fraudulently endorsed avenues of recourse.
Thank you.
All right, thank you.
We're not endorsing it. Thank you. Ms. Miller, anything else?
I know you folks are tired. I heard
You're the first one?
You
You're the first one? You missed the first one.
You really
Missed the first
missed
one.
a good
You
one.
wouldn't realize, you're surprised how tired you are.
Oh, boy.
I just a couple of things. These lien statutes were made to protect, that's what Blankenbaker says. They're to protect the medical provider. Imagine if something like this happened to, say, Good Sam Hospital or something.
Well, the statute rose as a result of Maricopa County getting aced out as a result of the Barfield case.
Right,
So,
exactly.
you don't have to worry about Good Sam.
Yeah.
And
So-
because the legislature understood that the county was getting hit and so was the state.
As far as the McReynolds case is concerned, if the court reads it carefully, it'll see that when they sent that check out, they sent two releases. They sent one to the patient and they sent one to the lien holder. And when the patient refused to sign the release, of course, the lien holder then didn't have any, obligation to sign a release. He wasn't getting paid. So that's, they did it the right way. We don't even know the depository check from Miss Willis. We never got a copy of that. We got a copy from Miss Berumen of the other one, so we know what her depository bank is. But we don't even know what the depository bank is. And I can just imagine calling up the depository bank and saying something like, hey, you didn't get both signatures on this. We'd like our money. We asked them. All they had to do was make a phone call to their own bank. I think this court understands what's going on, and I'm not going to bore you any longer. Thank you for your
Thank
time.
you, Counselor. Mr. DeLong, I did have one other question for you. Let's assume we reversed. I know you thought you were done, but not quite.
Oh,
but
I'm
you're
always
not.
happy to talk more.
Okay. I just have a quick question.
Been very patient with us.
Let's
Thank you.
assume that we reversed on the lien issue. Does Farmers have any other defenses to this? I mean, are there any other issues that have to be resolved by the trial court? If that was the only issue that we reversed on?
Well, technically, yes. If you look, Blankenberry talked about, you still have to, the medical care provider still has to prove up that they have the, and again, I can pull it out if you
There are
really
other
want to. but-
defenses that.
Yeah,
I'm
but
just
essentially,
asking.
yeah, there is.
But
other
there's
differences.
something that still has to be resolved.
It's very
It's not
minor,
that
to be
it's-
quite frankly,
It's not
but
like, it's not like we could remand and say enter judgment if we were going to do that.
technically that would be incorrect. Again, for all practical purposes, the defenses are whether the medical, whether the claimant agreed with the care provided and there was a reason, blah, blah, blah. That's the kind of thing.
Okay, thank you.
You should.
Yeah, go ahead. Still have 3 minutes.
Made a settlement with the patient for specific amounts of money. As far as I'm concerned, that concedes that the amount of money that they paid them was for reasonable expenses and reasonable treatment that they received. That's all you're going to get, and so that's what we consider reasonable. So they've already decided what was reasonable. I don't have to
Well,
prove it was
I think
reasonable.
that if we were to remand, all that still needs to be sorted out by the finder. of
And if it's clear, if it's as easy as that, the trial court could do that. It may be a very simple matter.
Perhaps not this trial court.
Well, okay.
They're real
Thank
busy
you,
down
counsel.
there.
Thank both counsel for their arguments. We will take this matter under advisement and issue a written decision in due course. With that, we stand adjourned.
Thank you.